Hi, my name is Joe Esquivel and I'm with the Mortgage Compliance Investigators. Today's video is on quieting a cloud on title. What is it we are saying when we state a cloud is on my title? First off, we must understand what a colorable claim to title is and what title is, as those are two distinctly different things. A colorable claim, as defined by Legal Information Institute of Cornell Law School, is stated as a plausible legal claim. In other words, a claim strong enough to have a reasonable chance at being valid if the legal basis is generally correct and the facts can be proven in court. The claim not actually result in a win. The banks are hoping that the hearsay claims to title that are recorded into public record will be enough to steal the homes from beneath the homeowners. As it is defined in the Hawkins versus Title Insurance and Trust Company case, title is complete ownership in the sense of all the rights, privileges, powers, and immunities an owner may have with respect to land. The documents that are filed into public record are done to memorialize transactions. They do not cause the transactions. When the document, being either an assignment of mortgage or an assignment of deed of trust, is filed into public record, the purpose is to memorialize the transactions of the sale of a tangible negotiable instrument as well as the acquisition of rights to title. It does not cause the sale. The sale is to be done in accordance to your state's equivalence of the Uniform Commercial Code Article 3. The filing of the document purporting to be an assignment of mortgage or an assignment of deed of trust is to let the world know that a superior claim to title has taken place. Recording of an eligible document into public record gives constructive notice to the world as to what has happened. The legal question that is never asked should be, is this document eligible to be recorded? In the majority of the foreclosure actions that are taking place against homeowners, the claim holder in due course has not acquired complete and lawful ownership of title. Although mortgage servicers are able to foreclose under local laws of jurisdiction, that ability arises from an agent-principal relationship with the owner of the indebtedness and that of a perfected right to the real property. Therein lies the problem. The properly perfected claimed right has not been lawfully acquired. A third party attempts to exercise a right on a homeowner's property without lawful authority to do so according to statutory requirements of law. When a quiet title suit is filed and the cause is for equitable relief, you are going into a court of equity when you should be going into a court of law. In going into a court of law, there are a few things to take care of first. First, before you take any action, there should be a findings of facts and conclusion in regards to the true sale pertaining to the title of real property. The following questions need to be addressed prior to taking any action. What did take place? What did not take place? When was this to take place? What was supposed to take place in accordance to the statutory requirements of law pertaining to negotiable instruments and real property? It is only upon using a correctly applied methodology to identify the parties entitled to enforce and note that a determination can be made if there is a party entitled to enforce. Upon applying the correct methodology and ascertaining the facts, one can then identify as to what action one would need to apply in order to achieve the desired results. Quieting a cloud on title means unraveling the facts and hearsay claims of colorable title from the statutory requirements of law required to achieve a properly secured title with rights. As there is controversy pertaining to superior claims to the title of real property, it would only make sense to this writer to have a determination of the courts as to the legal position of these parties making a colorable claim to title of real property. One way to abstain the status quo determination of parties in this controversy would be through the use of a declaratory judgment, which is a legal determination of the courts that resolves legal uncertainty for litigants. The declaratory judgment is generally considered a statutory remedy and is not an equitable remedy in the United States, and thus not subject to equitable requirements. Declaratory judgments can provide legal certainty to each party in a manner which could resolve or assist in disagreement. Often an early resolution of legal rights will resolve some or all of the issues in this matter. In looking at the actions in which a declaratory judgment may have positive results, one would look at the enforceability of the security instrument and the enforceability of a promissory note as to the current party claimant and interest. Laying the proper foundation of findings of facts and conclusions gives teeth to the cause of action of slander of title for declaratory judgment. There is no such thing as a free house. It is only the loss of an alternative means of collection that is lost. One cannot lose what one never acquired properly in accordance with statutory requirements of law. They cannot lose what they have never properly owned, which they have never properly acquired in accordance with law. Thank you very much.